every year for many years, Roger Kuypers has given us a great overview, often with Ling Wang, but this year we have a new face. We have Nina. Nina, last name, please. Rajic. Okay, so two great experts on IP. I'm going to pass it over to them. So thanks again.
Loading up. All right, well, thanks for coming this afternoon. We've got lots to cover, so we'll get started. It wouldn't be a legal presentation without a disclaimer. We know what we're talking about, but sometimes we're wrong and you've been warned. So there you go. I'm going to start with a question. I'm not going to answer it right now, but it's something you could think about if you get bored. Now, of course, the benefit of being here in person is that also, if you get bored, you can like look out the window and dream and that. Although I was thinking the folks at home get to surf the web if they get bored. So maybe that's a little bit more exciting. But anyways, we'll try to keep it interesting. So think about what is the most valuable asset on the planet. I think you have an idea where I'm going with this because it's probably not going to be something tangible, but there we go. So we're going to start with a few comments about why IP protection is important. And so obviously it's a valuable commercial asset and it's the most valuable asset for most companies. No, it says for many companies, but we're coming to appreciate that it may be the most valuable asset. Once a company gets to a certain point in its development, the most valuable group of assets that it has. Now, IP provides a competitive advantage. So for example, you have technologies, for instance, if you're looking at drug development that make a drug more, have greater efficacy or have greater safety. And then of course, you've got all sorts of advantages in different areas of technology. Also, IP can protect you from competition. If you develop an innovation and you get a patent, and Nina's going to be talking about patents, you can prevent others from using it. So that's something that can be very valuable to a company. Now, one thing that we've come to appreciate is that investors, acquirers, and customers care about intellectual property. And one of the things that we do is, primarily at Fasken, we work for startup companies like your companies. But over time, we've increasingly done work for the dark side, like VCs and companies that acquire your companies, because you can appreciate that the technology cycle in our local market, and that maybe reflects the size of our capital pools, it reflects the size of our local markets. But often what happens is that if you're really successful with your technology company locally, you'll get bought out and by a larger company based somewhere else, and often in the US. So part of what we do is we act for those companies and we act for the VCs and we do due diligence for them. And we'll get called in to the data room and, someone will look about corporate stuff and other things. We will focus on IP. And so, we'll look at the patents, chain of title in particular, who owns things. Can you show that you actually own your inventions? What were the contracts? What employment agreements did you have? And we've had instances where we've had very significant deals. In fact, in the last couple of years, there were a couple of deals that were just over $200 million. And one of them actually cratered because of IP. And one of them, there was a renegotiation of, there were concerns that arose because of IP that came out in our due diligence. And in that particular instance, what they did was, I think the deal may have been around 240 million. They ended up taking a 50 million holdback and doing an earnout and all that. So ultimately, it didn't cost them on price, but that's one of the points that you can get that can come up. So if you have troubles in due diligence with investors, acquirers, they can grind you on price if that isn't clean. So the important thing is learn early, do things right with respect to IP, and then when you get to that, that really critical potential exit, you'll come through with flying colors. So what makes IP different, of course, than other types of intellectual not intellectual property, but his tangible property, is that it's so easy to replicate. If you have a trade secret, if you have an algorithm that's in your AI app that does something very special and other people find out about it and get a copy of it, you can reproduce things, intellectual property, over and over. You can copy it thousands of times. And there's no real cost to that. I mean, certainly if the theft is discovered, then there could be significant costs in the form of litigation, but it's not like a tangible asset. Real estate's not going anywhere. And equipment, it's difficult to move. You can lock it up. IP is not like that. You know, once the horses have left the barn, Nina will talk about that within the context of trade secrets. It's gone. And so that's the reason why it's important to protect it. And the way that you protect it is different than tangible assets. So you'll see that there's a bit of a recurring theme in our presentation today, and that has to do with we're kind of on the soapbox of the value of IP. And so what I have here is it's a bar graph over time that goes from 1975 to 2020. And what you have is, and what it does is it represents the value by assets of the S&P 500. And you have two classes of assets. One is represented by the gray, and that's tangible assets. So that's, you know, inventory, factories, cash, things, more traditional types of value. And then what you have in the blue, or is it kind of more of a turquoise, is you have intangible assets, which are primarily intellectual property. So things like trade secrets, brand value, software, patents, those types of things. And what you can see, and this is going back to my comment earlier about, for, you know, many companies, IP assets represents most of the value of a company. And what's happened from 1970 to 2020 is that on average, the value of an S&P 500 company went from 15% intangible assets to 90% intangible assets. So most of those very valuable companies are almost entirely comprised, or at least, you know, 90% or more of intellectual property assets. So there. So we're going to talk about the four pillars of intellectual property: copyrights, trademarks, trade secrets, and patents. I'm going to talk about what I think are the fun ones, copyrights and trademarks, and then Nina's going to talk about the two categories of intellectual property that protect inventions. And so the first being trade secrets and the second being patents. Now, what we hope you get from this primarily are three things. One is to be able to identify the type of intellectual property. It's kind of confusing. It's a bit abstract, and lots of people kind of confuse different types of intellectual property, and that's normal. So hopefully we'll help with that. Number two, and this is really critical, is ownership. I mentioned chain of title before. So one of the things that you want to be able to demonstrate as a company as you move down the road, and it becomes particularly important when you're going through a due diligence exercise in the course of financing or an exit, is that you own the intellectual property. And so we're going to talk about how ownership is determined and throw in a few tips to make sure that you do own your IP. And then finally, we'll talk about IP protection, because that's important as well. So we're going to start with copyrights. So copyright is the sole right to produce or reproduce a work or a substantial portion of a work. And I'll give you an idea of what works are. They're defined in the Copyright Act. And the really important thing to understand about copyrights is that they protect the expression of an idea, not the idea itself. Ideas may be inventions, they can be protected by trade secrets or by patents. But copyright protects the expression of an idea. And I'll give you an example. If I have a melody in my head, and perhaps even some words, so a song in my head, that's not protected by copyright. It doesn't exist in any type of fixed form. But if I were to write down the music and write down the lyrics, once that's in fixed form, that would be protected by copyright. And so the concept of work includes a number of important things. So software, data, website designs, articles, photographs, graphic designs. So the examples I have, one is very old fashioned. Copyright protection goes back to the 1800s. And so sheet music, so that's when the idea of the music is kind of committed and expressed and then it can be protected. And we have a design there, a common design used in apps. And then finally, what I wanted to show was, this is the Life Sciences BC web page, or the main page. And so it is in and of itself a work, but it includes a number of different works. So you'll see that there's a photograph, there's the design. So you've got the photograph, you've got the Life Sciences BC design there. And so that design logo, not the words Life Sciences, but the actual design is protected by copyright. And then you'll see there's some text there. And at the bottom where you see a bunch of sponsors, you'll see some designs that they have. Those are all protected by copyright. Each one of them is a work. And then when they're put together into one work, it creates a work, and that's also protected. So what are the requirements? There's really only 2 requirements in order for something to be protected by copyright. And copyright's a great deal, because when these requirements exist, you get like 99.5% of the protection that you'd get if you registered copyright. You don't have to register copyright. In fact, we don't often recommend it. Sometimes if you're headed into litigation, and you can appreciate it because there's so many things that are protected by copyright in your business. You're not going to go around, oh, let's register that, let's register this, let's register that photo, let's register this app. That's not necessary. So the 2 requirements are originality. And so that test varies a little bit from country to country, but in Canada, the test is that it needs to be more than a copy of another work. It needs to reflect the exercise of skill and judgment. And so what I have on that side are what is known as, well, it's a picture of what's known as the white pages. I don't know if it exists anymore, but it used to be before the internet. If you're old like me and you needed to look up someone's phone, you couldn't just use your phone because your phone was just a phone. In fact, a lot of people didn't even have cell phones. It was awful. And you're so lucky you missed it. But what would happen is you had these huge books full of people's phone numbers, and they'd be arranged alphabetically. And so what would happen is someone copied the white pages. And so the court held, this is the Teledirect case in Canada, they said, look, arranging names alphabetically and putting a number next to it doesn't pass this test. It doesn't require that much skill, but pretty well everything else does. And something, like Starry Night would certainly be protected by copyright. So for many works, I think you can probably operate on the assumption that they're protected by copyright. But if it's really rudimentary, if it doesn't, and if creating it didn't require the exercise of skill and judgment, then maybe not. But you get those 2 things, you got copyright, you didn't have to pay a lawyer for it, it's great. Yes.
A little bit on skill and judgment. Can you give an example of skill and judgment?
Well, I guess organizing things in alphabetical order don't require sufficient judgment. But like for example, if you're coding, you have to think about first of all, there's the skill, understanding the language of coding, right? And then there's the judgment. Let's say you're creating a subroutine and you have if-then statements. There's a logical component that you have to work through. That's somewhat complicated. And there's a judgment. And you may think, well, I'm not going to put this statement in the middle of my if-then loop because it's going to, the program might not run. So that would certainly satisfy it. If you're looking at within the context of photography, the skill and judgment may have to do with depth of field, focus, light, things like that, composition. Composing the photograph could be skill. Now, the interesting thing now is so much of that is automated, right? Like, and I'm not going to start a discussion about copyright and AI, but what if AI creates something? Whose skill and judgment is it, right?
I think my question was more around the research-based creation of information. So what if it is based on 30 sources, use judgment?
Oh, that's fine, because what you're doing is it is both a skill and it entails judgment to decide what to include and what not to include, and the conclusions that you draw. And so that's kind of a no-brainer. That's protected for sure. So I'm going to introduce a concept that a lot of people aren't familiar with that can be very, and this is one of the big pitfalls of copyrights. And if you are dealing with a company that deals with code or user interfaces, then this is a big deal. And so what happens is the Copyright Act in Canada, not the US and not in many other countries, but in particular in Canada, has a concept of moral rights. So if you're the author of a work, the person who creates it, not only do you initially own it, we'll talk about that in a moment, but you have something called moral rights. And so if I create, let's say I create a song and I record it, what I would be able to do, what moral rights entail, is that they allow you to prevent someone from modifying it, right? So you can't change it. That would be an infringement of moral rights. It would break part of my copyrights. And you also wouldn't be able to use it for things that it wasn't originally created for. Now, let's say that you pay me, horrible, horrible idea, to write a song and then record it, even worse. And I'm not a musician. I think that's kind of coming through. So what happens is that you would have the song, but you wouldn't be able to make any changes to it. And you wouldn't be able to use it. Like, let's say it was just supposed to be for put on the radio or for kind of general enjoyment. But then along comes a political party you disagree with. And this happened in the US, right? With Bruce Springsteen and Born in the USA, the Republicans were using it. And he said, hey, you can't use my song. Like, he sold his publishing and he sold all his rights to Columbia Records or something like that. Now, if that was Canada and someone used your song for a political purpose, you could say, no, stop, you can't do that because we have moral rights. But they don't in the US. So this is all very confusing. But I'm going to put it in maybe an example that makes more sense. Let's say you hire a coder to code something for you, for your company. And your agreement's silent on the subject of moral rights, right? And then you say, hey, thanks, you pay the coder. And then hey, the coder is okay, but not great. And you decide, well, you need some bug fixes. You're going to do a new version. You're going to do some updates. You hire someone else to code it. You can't really do that because the code, the updating and the bug fixing and the new version are all modifications of the original code. And so to do that, the new coder you bring in would be infringing the first coder's moral rights. And so the second coder could say, hey, I saw you got a new version. You better take that down. You could do that with same with if you hire someone to create a website for you, you're always updating it, right? But the thing is, updating a website, if the original person who created the website hasn't waived the moral rights, it infringes their moral rights, and they can actually go and say, stop it. So the picture here is the atrium in the Eaton Centre in Toronto. And what you see there, and it's a awful grainy. I was in Toronto and I said to myself, I'm going to go there. I'm going to take a picture that's clear, that I'm not infringing copyright by including it in a presentation, but I keep forgetting to do it when I go to Toronto. So what happened was one year, the people who managed the mall put Christmas ornaments on the, it's actually Canada geese. It's a bunch of sculptures of Canada geese that are suspended from the atrium. And the artist said, stop it, get rid of, take down, I don't agree with this. This is my sculpture. These are my sculptures. Take it down. And then the people who run the mall said, well, no, we paid you. We own it. He says, well, that's an infringement of my moral rights. Went to court, got an order. They had to take off the decorations. So that's just coming out of left field for a lot of people, right? Most people don't understand there's a concept of moral rights. And this is something that they're going to look at when, and I've had to do that in the midst of financings. Like, does each agreement with the employees, does each agreement with the contractor waive moral rights? And all you need is something like that little statement there. It's like one sentence to fix it. So in your employment agreement, it says the employee shall and does hereby waive all of his or her moral rights in the work product. Boom, done. Move on. Right? Move one step closer to the financing. So ownership. The author, and this is a second pitfall, and then I'll move much quicker, but these are the two things that people get wrong that cause trouble. The owner of copyright is the author. So the person, so for a photograph, the photographer, for the coder, so for the software, the coder. Now, the good thing is that at law, employees, if you hire someone to code, to write copy, to otherwise to create your website, and they're your employee, not a contractor, but an employee, then the employer is automatically the first owner of copyright. So this is not a problem in the same way with employees that moral rights are. But what this does mean is that if you want to own something and you contract it out and your contract is silent as to ownership, you don't. What a court would hold in Canada is that you have an implied right to use it. So it's not so crazy that you'd go out and pay someone to create something. You tell them what you want, they create it, you pay them, and you don't get to use it. You get to use it, but you don't own it. It's kind of like when you go to a photographer and you have a sitting and then they take the pictures, but you don't get the negatives, like you don't get the original digital copies because you don't own them, right? You've just got the right to buy from them. Yes.
Is that applicable only for code written in Canada? What if the code is?
It varies. So oral rights are specific to Canada, and there are just a few other countries that have kind of similar rights, but for the most part, not an issue. In the United States, they have a concept, it's called work made for hire. So what often happens is that people, when when you're just getting started, you don't have a lot of money, you can't afford lawyers, you go online, you get a contract for this or that. And sometimes we'll be looking at a Canadian company's contract for like someone who did coding for them, and it'll say, all the software will be considered a work made for hire. Well, that doesn't work in Canada. But in some other countries, that is an issue as well. And so what happens is that when you're doing due diligence, and I think even if you're looking at US contracts, they'll want to see words of assignment, right? So for example, even in Canada, the statement, the company's gonna own all the code, or the company will own all the code. No, what you really need is you need a statement that says, like that the coder shall and does hereby assign or will assign all of the rights, title, and interest in the code. So that it's important. You just get that right. You can put the moral rights waiver and the ownership statement all in one sentence. You get that sentence in the agreement and you've just taken care of both of those potential concerns. So I'm talking a lot, but Nina's used to that. We've got a bit of time. But I think this is somewhat useful just to drive the point home. So here's a test case. So you're a company and you're developing an MRI application. So what you're going to do is you're developing an app that looks at MRI images, MRI results, and analyzes them and flags perhaps if you think that some of the images reveal something that may be cancerous, right? And we see a lot of this, these types of technologies in healthcare, where you're applying AI to replace radiologists, essentially. But a lot of people that are investing in these companies are radiologists, because I think maybe they've realized that their competition is a computer. So you have 4 particular people or parties that are involved in the development of this app, this MRI app. And you've got the person who came up with the idea, right? Hey, great idea. Let's have an app to analyze MRI images. Then you've got the software architect. So you've got someone who says, okay, I know what you need. You need this. You got your algorithm in the middle, and then you're going to have like an input-output thing, and all these kind of modules. And then you have someone like a coder working under contract, and then the person with the idea and the software architect will say, this is what we need you to write. And then you've got the company that paid for it, right? So the company that maybe hires the software architect, and maybe the person who came up with the idea founded the company. And so the company pays the coder to work under contract. Now, let's say none of them have a contract. So who owns the code?
Coder.
That was good. Never forget it. So copyright protection, as I mentioned, arises automatically. You just need those two things. It needs to meet that requisite level of skill or judgment, and almost everything does. Pet Rock's not, but it's not really copyrightable. And when you see, sometimes you've got a C in a circle, and so it's good, but you don't have to put that everywhere. And it's not a requirement of having copyrights. What it does is it kind of tells the world, you know, this is a work and we own the copyright. So you put the name of the owner and the date of first publication of it. So that's a good thing to have at the bottom of websites and things like that, or next to images. But clearly you're not going to put Circle C on everything that's protected by copyright. Registration is simple and inexpensive. It probably costs about, the fee is probably somewhere in the neighborhood of $300, but the Canadian Intellectual Property Office doesn't even take a copy of what you're registering the copyright for. You just put the title, the author, some other information. And as I mentioned, we typically don't recommend registration, and most works are not registered. Copyright management, it goes without saying, but focus on ownership and rights. How are the things protected by copyright in your business developed? Who develops them? What's the agreement? What does it say about ownership? Does it waive moral rights? And then here's the magic sentence. So if you have a contract with a contractor, and let's say in this particular instance, you're signing an agreement with a company that's developing your website. So it's a company and not the person developing the website, but they have employees that are going to do it. So what you'll put in that agreement, or you'll make sure it's in there, contractor shall and does hereby assign to customer all rights, title, and interests in and to the deliverables, and shall ensure that each author of the deliverables waives all of his or her moral rights in and to the deliverables. Just an unlovable sentence, but you have this, and that really goes a long way in addressing the concern. Any questions before we move on to trademarks? Yes.
Is there a reason somebody should not do a copyright?
Register it? Yeah, to save $250 or $300. I mean, go ahead, but as you can appreciate, so many of your company probably has lots of works, not just a single website, not just a single app, but there's lots of copy in your collateral materials. There's your design of your trademark. And so you can run around and register everything. The rights that you get just automatically are 99% of the rights that you would get if you registered. Yes.
When you're submitting a copyright application to get a registration, which I've never done.
Most people don't.
Yeah, but what is it that you're submitting? Like the entire work?
They don't want it.
But then how does the court know that registration number?
They don't really. What happens is you put the title of the work and the authors, the publication date. There's maybe a bit more information. You pay the $300. You can do it online with the Canadian Intellectual Property Office. And sometimes people do it before they go to court, because there's an evidentiary benefit. Like, so for example, say you wrote a book and someone was ripping it off, you would register the copyright, and then you get like a certificate from the Canadian Intellectual Property Office, which is prima facie evidence of your copyright. So rather than when you're putting evidence in court to sue someone, you could just like hold up the certificate, and that would just help. Yes.
If you didn't have the certificate and you created the document digitally, let's say, so it would be the title of the Word document, the date of creation stamped in the file, and you, the owner of the file, and as long as you're part of the company.
Yeah.
That's your proof of.
Yeah. And it's not like patents, you don't have to do it right away. So the thing is, if you could just not register copyright, and then if you go into court and it's really around one work, maybe you go ahead and register it at that point, just to make it easier.
So it can be done.
Yeah. Yes.
Is this a general concept or just only in Canada? This idea of
General concept, mostly. The particularly Canadian aspects are moral rights. So what happens is that there's a copyright convention and a bunch of different countries recognize each other's copyrights. So there's a reciprocal recognition so that if you create a work in Canada, you're going to have protection in countries like most other countries. Yes.
Well, for content generation and sharing companies, let's say Wikipedia took a bunch of their articles and internally used it to train an AI to generate a smaller version of that data.
Yeah.
Would Wikipedia own the content generated from the AI built on the articles posted by their customers, or do
I
the
said
customers?
we weren't going to talk about AI. It depends. So it depends on the country. So there are a couple of key questions that arise from AI. First of all, is the product of AI protected by copyright, right? And so this is being litigated in different countries. And I suspect at the end of the day, the consensus should be that yes, a work, although it's created by AI, is protected by copyright. The second question then becomes who owns it. And so it probably makes sense that the person who instructed the AI would be the author because they played the role in creating it. But there are a number of things you'd have to look at. Like, for example, would it be considered a derivative work of the article that was reduced in size, right? And so then you get into that. Maybe there's a test. In the early days of sampling music, when people, like rock bands or people who owned recordings sued rap artists that were sampling there, then they would come up with a test that you could have 1 beat or 2 beat. And that wasn't infringement, but if it was more than 3 beats, it was. And so you could see that over time, those specific questions, they get settled once something goes to court. And then you get an outcome. And what you really have to look at generally when you're looking at platforms that deal in content is look at the terms and conditions of use, right? So if you post something to YouTube, does that mean that you're giving ownership to YouTube of it? I think their terms and conditions don't say that. But I think that if you post something, the terms and conditions say you're granting a license for them to use it. And it's important to know that if you're in that business. If you're just doing it for fun, and it's not as important. Shall I talk about trademarks? Okay, I'll move quickly. So trademarks, the key purpose of a trademark is to indicate where goods and services come from. They are signposts that customers carry around in their head. And they also have meaning vested in them. You see, for instance, Apple, you like and trust Apple. You expect good things to come from Apple. A lot of people do, maybe others don't. That's not true for all brands. Some brands are not known for good quality. I won't pick on car brands because there's always someone that owns a Range Rover in the audience. No, I'm just kidding. Trademarks are very, very valuable. And so they could be words, designs, the shape of the goods and their packaging. So for example, the picture of the Coca-Cola bottle, yeah, there's a trademark on the front, but the actual shape of the bottle is a trademark. You have combinations of colors. So for example, MasterCard has registered the combination of those colors in connection with credit card services. And so I expect, IKEA has probably registered a combination of blue and yellow in connection with furniture retail, perhaps furniture too. There are also sounds can be registered. So when you start Netflix and it goes boom, boom, that's that percussive sound, that's a trademark. And that's likely registered in a number of countries. Because when you hear that, you immediately associate it with Netflix, right? And that's the power. If you're not looking at what's on the screen, suddenly you know, okay, well, it's Netflix, right? Trademarks are important for the reasons that I mentioned, but also the goodwill associated with products and companies reside in their respective trademarks. So think about when you first come up with a trademark, and the best trademarks are ones that really don't have any meaning until you bring it out into the marketplace. It's like an empty vessel and you fill it with the experiences that your customers have with your goods and services. And they can be good or they can be bad. And so consumers make decisions on the basis of trademarks. So The Apple brand, this is there's a company called Interbrand. They do a survey of global brands every year. They come up with their top 100. This is the top 10 for 2023. I should update that. But, sorry?
I would today.
Oh, yeah. No, this isn't stock market. This is, although there's a strong relationship of the, yeah, exactly. Today was a good day, apparently. So the top brand in the world is the Apple brand. So it was valued at so $500 billion. So that's the most valuable brand in the world. It's the most valuable asset in the world, as far as I can tell. I thought about it. I mean, what's expensive? An aircraft carrier? What, $15 billion or something? But if you come up with a more valuable asset, let me know. You know, an asset being something that a company can own or a company owns. There we go. Requirements, distinctiveness and use. So for a trademark, you need to use it in commerce ultimately. You can register it without using it. But over time, if you don't use it, those rights can be challenged. And use, for tangible items, you can put it on the packaging of a item. You can put it on the item itself. Now for services is a bit tricky because services are intangible. So the main way that you use a trademark in connection with services is in the advertising of those services, which includes the trademark. So if you're a services company, maybe it's a SaaS services, if you've got that trademark prominently on your user interface, on your website, then that should be considered use. Distinctiveness, there's two main aspects to it. One is it can't be descriptive and it can't be similar to other existing trademarks in your field of commerce. So descriptiveness, there are certain words like, for example, fresh in connection with bread or safe in connection with cars. That really describes cars and fresh describes bread. So that's not a trademark. A trademark is supposed to be distinct, something different that when you see it, like this isn't so good because Boobly is close to bubbly, but, and don't even mention Save on Foods, but anyways, don't be descriptive. Confusion, there's two reasons why you don't want to adopt a trademark that's confusingly similar to others in your field of commerce. One is you're going to have confusion in the marketplace. You're going to have trouble building brand equity, but the second and more compelling reason is the other guys may sue you. So that's not good. Ownership, you'll see that when Nina talks about trade secrets and patents, ownership is kind of like copyright as well. It's generally speaking the people that create it. Trademarks are different. Person that owns a trademark typically is the first person to use it in commerce or to register it. That's the indicia of ownership. So if you come up with a great brand and you have a board meeting of your company, you say the brand is going to be this, and then they go out and register it. And then subsequently you just go, no, that's mine. I thought of it. In the trademark world, that doesn't matter. So one important thing to understand is that trademark rights are specific to the field of use. Delta, 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 great mark for airlines, hotels, faucets, not right. It's the same mark, but you're not going to go buy a faucet and end up with a plane trip to Hawaii or something like that. Although you would like that. She loves Hawaii, but something to bear in mind. If your business is international in scope, there's an important thing to consider as well, and that's the connotation associated with the trademark. And so what happened in 1997 is that Nike came out with the Airflame logo that they put on the back of their running shoes. But unfortunately, the logo they designed was Arabic for Allah. And so that was somewhat controversial. And not to be outdone though, 22 years later, they made the same mistake, but it was even worse. They put the logo on the sole of the shoe. So don't do that. Think about if you've got an international offering, think about what it means in foreign countries. So for example, Chevy Nova, another old person reference, it used to be a car. And it was a very popular car, not as popular as like the Volkswagen Beetle, but quite popular. And they were selling it in Mexico. Nova in Spanish, I don't speak Spanish, I'm sure some of you do, means no go, like doesn't go. So it was the car that doesn't go. Bad marketing. Searching and clearance, I'm just speeding up a little bit because I've been going on way too long. But so you're managing your IP and you want to adopt a new trademark and you've listened to the things that I said before in terms of distinctiveness. It's not going to be descriptive. You need to know how is it confusingly similar to others in your field of commerce. You do searching and clearance. And there's two places you look. You look on the trademark registries, so the SIPO trademark database, USPTO. If you want to, there's a great database. You go to the WIPO, World Intellectual Property Office site. You can do a global search of trademarks and you can search there. And so you search because if people, remember there's two ways that you can own a trademark. One is by registering it. And of course, the other is by using it. So the other thing you need to search is the marketplace, because there is a concept of common law rights. So people, if people don't register a trademark and you go, oh, great, nothing on SIPO, nothing on USPTO, you apply to register it, use it in commerce, and then you find out that someone somewhere is using the mark, they may have common law rights and senior rights to it. And so what you would do is you would do Google searching. And we have actual full availability searches that we can order where we go to a search agent and then we can review that. But there's lots you can do. This is the SIPO website, easy to use if you're searching for trademarks. And this is the USPTO one. Any questions? Yes.
Recommend registered trademark?
Absolutely. Big difference. Because the rights you have through use are limited to geographic scope. So if you opened a restaurant, not that you're in a restaurant business, and you just use it locally, I could go, hey, great concept, and open one in Edmonton and Toronto and Montreal using the same trademark because they're limited rights. Also, the things you can do with common law rights are quite limited too. So yeah, by all means, register the mark. And over time, what happens is the brand becomes the most valuable piece of IP in a company. Think about Apple and think about what the original iMac is worth today. I mean, not as a collector's item, but as a, or an iPad, or the products keep changing, but the brand holds the value. Yes.
When you say in the case like I'm a restaurant owner and I've owned a restaurant for 15 years and I don't register my brand for the trademark, and somebody today register the same thing, exactly the same thing. So I'm gonna lose that.
You lose it outside of your own market. I don't think they'd be able to make you stop because you had senior right, but that they could, outside of your geographic area, they'd be able to use it.
Oh, so outside Canada would be stopped from using it.
Well, even outside of Vancouver, because you look at the nature of the business. Now, if you've got an online business and you have a global footprint, you could argue that your common law rights are pretty significant. But the thing to bear in mind is that not all countries are common law countries, right? Obviously, the US, Britain, Australia, New Zealand, part of that Commonwealth. But some countries follow the Napoleonic code. You have code. And so you wouldn't have common law rights in France or in Germany. And so you just wouldn't have any rights.
For a startup business, do you register the name and the logo, or like color combination right away? Like, what are the elements that are like initial trademark?
Well, you start, if someone comes to me and says, we can do the logo with the name, I always say the name, right? I mean, you've got Nike and the Nike swoosh, protect Nike. The swoosh may be later. And it's often the case that our clients don't have, the money to do the name and the logo and the combination of the name and the logo. But when you work for other companies that are more established, that are super brand focused, like food and beverage companies, then they'll definitely go there. Their step.
At what point do you register, like the brand or the name? Is it very early on, or do you wait until you get a first client, or do you?
Oh, the earlier the better. And it's a little bit tricky with countries. So some countries are a great deal, like the European Union, 27 member states for one price, right? That's pretty good. Almost everyone does Canada and the US. And then you look at other countries. The problem is that the problem we had with domain names with cyber squatting from 25 years ago is now starting to show up in the world of trademarks. So someone will start, and this has happened to our clients. It happened to Aritzia. Someone else registered their trademark in, was it China or Japan? And of course, they had started where they started their stores. So it's good to at least register that that word mark in particular. There's a lot of shenanigans in China, so I definitely register in China. Yes.
What are the costs associated with registering a trademark?
Well, the cost of a trademark application from beginning to end, including the filing fee, registration, the government fees, right? And the lawyer's fees is about $2,500 if everything goes smoothly. Some countries, like for instance, England, is a little bit less because, as you may recall, they bailed out of the EU. And when they did, the people were no longer protected. They were no longer included in an EU registration. And so they wanted to encourage people to register, so they kind of kept it inexpensive. The US is a bit more, let's say $3,500, the EU somewhere in between that. But I say if it goes to registration relatively smoothly, because what happens is if you were to pick a trademark that was too close to someone else's trademark, or if it was descriptive in nature, and what happens is when it gets to examination, an examiner is going to send us a letter and say, you know, an examiner's report or a provisional refusal saying, sorry, this is not registrable because it's descriptive. And then we'll argue and a lot of times we'll be able to overcome that, but sometimes we can't. And all of that costs extra, right? If we get the letter, report it, provide analysis, create written arguments, that kind of stuff. Yes.
In case there is a conflict that we chose a name and there's already a name existing and we didn't pay attention.
Yeah.
What do we do to get over it? Like.
Rebrand. It almost never goes so a week doesn't go by that we don't either send out a cease and desist letter or respond to one that our client has received. We call them crapograms and we send them out all the time. And we respond to them, but they seldom go to court. I mean, the good thing about trademarks is that potential liability and court costs, all that is nothing compared to patents. You get into patent litigation, you got a budget, probably at least a couple of $1 million. Like that's completely different, right? But so usually the parties will go, you know, you'll get some advice. You'll go, you know, I think that they do, their evidence is pretty good. They used it before we did. We need to rebrand. Or very often you enter into a coexistence agreement. You're kind of in the same field. It happens with software. I mean, just because something is software touches on everything now. So you could say, we're going to stick to accounting software. You're going to stick to scheduling software, and we're going to be fine. And so you have a coexistence agreement and it goes.
Does it have a time limit? Like how long does a trademark?
Registration, the term now is 10 years. It's renewable, so it can go on forever if you keep renewing it. But remember, you got to keep using it too. So we do the trademark work for White Spot. They've been around for almost 100 years. So, and those trademarks, we just keep renewing them.
It takes 10 years to get a trademark or?
So the term of protection
or
is
the term
10 years.
Then you okay.
Yeah, some trademarks from some countries you can get within a year. But unfortunately in Canada, it's speeding up again, but because of COVID, the examiners went home and they stopped working. And they didn't want to go back to the office. And so at its worst, it was taking 4 years for a trademark application, which is like a page and a half, to get examined in Canada. We were the laughingstock of the global trademark community.
That's without opposition.
Yeah, I know. Just to look at it. But it's getting better.
Sorry, I have another question. Having the opportunity to file a trademark application here or in the US because they're so close, is there any benefit of doing it in the US? I thought of doing that because I was told it would take 10 months, whereas in here it take a bit longer. So would there be any advantage of registering in the US just to get the trademark faster, even though I'm trading here and I'm based here?
The rate, so the protection specific to the country. And so it's not like copyright where you've got this reciprocal recognition. And so, and the US is a very important market. So I would just do the US. If you were saying, well, maybe I do the US first, but you don't want to, you know, Canada's your home country, so you don't want to be stuck without protection here. And I should mention one last thing, I know it's taken forever, but is that we've got this Madrid system. And so what we can do now is we can file, if you file in Canada, we can use the Canadian application to file. We do it online in a bunch of different countries, and that could save a lot of money. But anyways, on to ideas.
Okay, so it's my turn now. And I'll be talking about how to protect ideas and inventions, and primarily you do that through two things, patents or trade secrets. And they can protect the same thing, but they don't necessarily always apply to an invention. And so a patent grants a time-limited monopoly to inventions that meet the requirements of patentability. In exchange for that, you have to fully disclose your invention. And then in contrast, trade secrets protect confidential business information by keeping the thing that makes you have a competitive edge a secret.
Sorry,
So-
could you speak a little louder?
Sure. What are inventions and ideas? Basically, what inventions and ideas are new subject matter, and it's anything that's new. It could be a new way of doing something that is already known, or an improvement on something that is already known. It can be tangible or intangible, such as a device composition, process, method, and it can be in any subject matter. It can be an algorithm for a digital animation that uses artificial intelligence, a computer networking protocol. At one point, popsicle was an invention. Somebody stuck a popsicle stick in soda water and it froze overnight, and they created the popsicle. It could be the Post-it note, and it could be really anything at any given point. So as Roger discussed with copyright, ownership is the same for trade secrets and patents. Generally, ownership goes to the inventor first, unless it's in the context of an employment agreement and the employee was employed in the course of their employment to do their inventions. Basically, what you want to do is have an agreement that tells you that the invention is going to be assigned to the corporation. Otherwise, there could be chain of title issues. As Roger mentioned, that has been a big issue on multiple deals. So trade secrets are confidential information maintained and protected by being kept a secret, and it could be formulas, practices, processes, algorithms, recipes, and other things like that. And they can be very successful. Think about the Coca-Cola formula. It has been maintained as a trade secret for years, and while people have come close, nobody has quite nailed it quite yet. Google has also kept its ranking algorithm a secret, and algorithms are a really good modern day example of trade secrets. And they're a really good modern day example of trade secrets because companies can keep the technicalities of their algorithms on the back end where people don't see it, and it can keep the proprietary aspect of it a secret, keeping their competitive edge and not ever having to share it to anybody. Another trade secret that's quite commonly known is the way Hershey's manufactures their chocolate. So the way they get their chocolate to taste the way Hershey's chocolate does is by their secret manufacturing process that still nobody knows. And then Procter & Gamble is included here because they keep their research methods a secret, essentially. And this is a really important distinction between trade secrets and patents that'll later be discussed. While business methods can be protected through trade secrets, they aren't necessarily protectable through patent protection. So at its core, a trade secret, to be a trade secret, needs to have three things. The subject matter has to be kept a secret. And that's really the principal purpose of a trade secret. Its commercial value is derived from being a secret. And this is what gives you a competitive edge. And the third part is that reasonable efforts have to be taken to maintain the secrecy of the subject matter. And what that counts in different situations is different, but basically you have to do everything you can to keep it a secret. And the potential benefits of a trade secret are that they never expire. Look at Coca-Cola, look at the KFC 11 herbs and spices. Still, nobody quite knows what they are, and they're going really well. They're also much easier to protect in that there's no governmental process or filing fees to protect it, unlike the patent process, which is very formal. There's a lot of requirements and there's a lot of fees required there. And it can protect a broad scope of subject matter. Patent subject matter is a defined subject matter where it quite frankly excludes certain subject areas from being protected. And on top of that, there's other requirements that need to be met to be patentable. Trade secrets don't have that requirement. And as long as you can successfully keep it a secret, you're good. The disadvantages of trade secrets are, the really big one is that it's subject to independent discovery. And what this means is that somebody else can be doing their own research and development and come up with the same thing, and you would have no recourse against them, essentially. The second disadvantage of trade secrets is that they're vulnerable to breach. So like Roger mentioned, once the horse has left the barn, it's left the barn. You can't really put the genie back in the bottle. Like, it's too bad, so sad. And to this point, reverse engineering is a problem too. So if you're gonna put your product out there and somebody can reverse engineer it, trade secret protection perhaps is not the way to protect your idea, and you should probably consider going through patent protection for that. And there is the ongoing responsibility to make sure that you have put into place policies and procedures to protect your trade secrets. Like, are you making sure that it's limited and who gets to see it, and other confidentiality measures like that. And here we have maintaining a trade secret. You want to put into place and maintain trade secret policies, which step one, identify what your trade secret is. What are you trying to protect as a trade secret? And then on top of that, with documents that relate to your trade secret, you want to make sure that everybody understands it's confidential and that nobody should share it. Third on that, access control is important. Inherently, the more people you tell something, the more likely it is that somebody's going to tell somebody else and that it's no longer going to be a secret. On top of that, you want to constantly have employee training so that they understand the importance of keeping it a secret. And you want to implement physical and digital security measures to make sure that you're not subject to like hacking or something like that. And you constantly want to be monitoring and enforcing trade secrets too. So that's a quick outline of trade secrets. Does anybody have questions? Yep.
Let's say, are you protected from corporate espionage with a trade secret? So if someone were to misrepresent themselves in order to get their hands on your trade secret, sure, there's nothing that you ever filed to say that it's yours, but if you were able to prove that there was some sort of malfeasance or someone was acting in bad faith to get their hands on it, would that person be subject to any legal ramifications or legal consequences?
It would probably be through something other than trade secret protection, like
You could sue them.
fraud and like something like that.
Yeah, we do that sometimes. I mean, particularly if an employee takes trade secrets to their next employer. We can contact the employer and make sure that they don't use those trade secrets. And if those trade secrets aren't disclosed beyond that, then you've contained the damage and you've kind of stopped it.
And that's also why in your employment agreements, you want to have strong provisions explaining what confidential information is and making sure that that obligation extends past their employment or their services if they're a contractor, and also assigning anything that they create to you too.
I think one more just kind of got my attention from the whole question around moral rights, but in this context, is there anything that makes trade secrets unique in Canada versus the United States, or do they both embrace the same philosophy behind a trade secret?
The principle is the same, but in the US, they have much more established common laws around that. So if somebody does steal it, there's a much larger established like common law case basis for them to go to court and use that to argue that somebody did something wrong.
I think there's even precedent that somebody went to jail.
Yeah.
Which would never happen in Canada.
I hear you. Thank you.
Will you even recommend this to any of your clients to abide by trade secrets? Because it looks so like complicated that you have to protect it for the rest of the business life and disgruntled employee and accidental discovery. Was there any actually good reason for?
The reason is it can last forever. Whereas like patent protection, you're only getting 20 years from your filing date. Whereas like trade secret, if you do everything that you can to keep it a secret, it can potentially go for much longer than that. Think about how long Coca-Cola has existed. That formula has been protected for far longer than 20 years.
I don't know if it's true, but I've heard one a while ago that even an employee of Coca-Cola tried to steal the secret or something, and it was, caught, or whoever gave it to report back to Coca-Cola because you don't want to go through the legal problem. But they just dodged the bullet there. Otherwise, everybody will have Coca-Cola by now.
That's true, but that was also in the US where they have a much more established trade secret precedent basis where the ramifications of that other person using that trade secret would have been pretty consequential to them too. Okay. So the other way to protect ideas is through patent protection. And basically patents give you the exclusive right to make use or sell your invention, what's claimed, for a time-limited monopoly. But effectively, people think of it as the right to prevent others from making, using, selling your claimed invention. As mentioned, generally your protection is 20 years from the filing date, but in exchange, you have to fully disclose how your invention works, such that the person who understands your subject matter, the person skilled in the art, will be able to recreate it with your disclosure. And right off the bat, some things you should know about patents. Again, publication is generally required, and patents are jurisdictional in nature, like trademarks. So you have to file a patent application in each jurisdiction that you want protection in, which ultimately can and as mentioned, for patents, there is subject matter that is and is not patentable. Abstract ideas, scientific theorems, natural phenomenon, pure mathematical algorithms, business methods, and mental processes are all considered to be not patentable. And this is because it's generally believed that people should be able to use abstract ideas and scientific theories and natural phenomena to themselves. And this is things like E is equal to MC squared, Pythagoras' theorem, the laws of gravity, stuff like that, or the ways of organizing a retail shelf like that. That being said, for other subject matter, generally the requirements of patentability for your subject matter that your subject matter has to meet is it has to meet novelty, non-obviousness, and utility. And what novelty means is you look at every single published reference and you ask yourself, does any single one of those published references have every single feature of my invention? And if one of those references does, your invention is not novel and it doesn't meet the requirements of patentability. Now, if there is no reference, that no single reference that has everything, great. You move on to obviousness. Then you bring in the question of the person skilled in the art. And you ask yourself, would this person skilled in the art, given everything that's been published and everything that they know, be able to come up with your invention without skill and judgment, or would they need skill and judgment? And if they need skill and judgment and to use some inventive step to get between what's known and to your product, then your invention is considered non-obvious. Otherwise, it lacks inventive step or is obvious and it doesn't meet the requirements of patentability. This is frequently, when you submit a patent application, this is frequently what gets brought back to you on examination by examiners being like, we found this reference and we think the person skilled in the art would be able to come up with your invention. And the third requirement, which is the easiest to meet, is that your invention has to be useful. And most of the time, that's fine, that's met. Yeah. On that note, something to be really mindful of is inventor originated disclosures. And what inventor originated disclosures are any public disclosure made by an inventor or somebody who has derived the information from an inventor. And public disclosure can be an article, it can be like a web post, but it can also be public use and public sale. And such disclosures can impact patentability because they can ruin your chances of, or it can make your invention no longer novel. And some jurisdictions like Canada and the US have a 12-month grace period, but many other countries do not. And that 12-month grace period basically means you've made your disclosure on date A, you have 12 months since date A to file your application in Canada or the US, you'll be fine. But as mentioned, there's a lot of other countries that don't have this grace period. So generally, our tip is file a patent application prior to disclosing your invention. That's the smartest thing to do. So the big question is, well, how do you know if your invention is novel and non-obvious? And similarly to like with trademarks, where you do clearance searching, you can do searching, and we can help you with that, but you can also conduct preliminary research by yourself. For example, through Google, or you can conduct patent searching through regional databases like CIPO or USPTO, or I personally like Google Patents. It's kind of like Google Scholar and it's pretty easy to use. And so this is like the homepage for Google Patents with the link. And you can search on it based on subject matter, inventor, patent holder, jurisdiction, and key dates. So in this picture, as you'll see, I just put in a query for everything that has been patented by Jeff Bezos, and it'll just pop out the references that it finds that have been patented that have named Jeff Bezos as an inventor. Similarly, you can search by the assignee, because remember, the inventor is the person who originally invents the thing, but the assignee is generally the company that the inventor assigns the invention to. So I looked at Nike and it just will pop out. It's popped out about 31,000 results of patent references that they currently have. Yeah.
Let's take Coca-Cola as an example. Could they now patent their recipe now after 25 years, given that it was a trade secret? And then, because it's not in public use because it's a trade secret. So I was thinking from my own company, could I keep things as a trade secret even though I release them today and then patent them 3 years later?
So the jurisprudence related to that is murky, in particular in the US. They don't like that currently because they view it as you're trying to take advantage of the system. And there's been examples where recently there'll be two companies who have like worked together to create something else, particularly to like market a new pharmaceutical drug, and nothing was disclosed to the public, but they've disclosed it to each other and they disclosed the partnership to the public. And the court in the US found that like the novelty requirements weren't met because of this like joint relationship. So basically, maybe, but it seems currently things are trending towards no, it's like a gray area yet again. Yeah. So just like from a formal perspective, just so you know, if you're going through the patent process, what it looks like, and your application will look like this too. There's a few different categories in a patent, and that's your abstract background summary, drawings, your detailed description, and your claims. For you guys, what's important to know is that the claims are by far the most important aspect of your patent, because this is what actually defines what you have, the exclusive right to make, use, and sell. The subject matter in your claims is basically your exclusive property. Everything else is supplemental to help describe your invention and your claims. And in terms of the patenting process, it'll start with preparing and filing a patent application. This will be submitted to the one or more intellectual property offices you want to have protection in. There'll be an examiner who will look at it. Quite frequently, they'll be like, no, we've found references A, B, C, and we don't think your invention is either novel or non-obvious in view of that. And at that point, you'll have the opportunity to write back to the examiner and explain to them why you believe that your subject matter does meet the requirements of patentability, even in view of the references that they've cited for you. If at some point you successfully persuade the examiner that your references are novel, non-obvious, and useful and are patentable subject matter, you'll move on to a granted patent. So, as we know, patents are jurisdictional in nature, and frequently people ask, where should we file? And for some things, it's very obvious, like if you're in a natural resources, if your invention relates to natural resources and it's very heavy related to that, you're probably filing in the jurisdictions where the natural resources are found. In contrast, if you're like in pharmaceutical or in a computer technology that can be used worldwide, it becomes a little bit trickier, and it's business decisions. And also it's about realistically, if you move on to infringement proceedings, how valuable do you think that'll be too? So costs can rack up from filing in multiple different jurisdictions, but one thing you can do is take advantage of some treaties to help defer some costs, essentially. And one of those things is filing a US provisional patent application. A US provisional patent application is not a real patent application. It will never mature to a granted patent. Basically, what it does is it secures an early filing date for you. It bookmarks your place in line. From that point, you have 12 months to file a subsequent patent application, a regular patent application. And for your subsequent patent application, you can apply that earlier filing date from your provisional patent application to that regular patent application, but only for the subject matter that was actually contained in the provisional patent application. If you include new subject matter, that will get the filing date of the regular filing application. And inventors and like companies frequently do that. One, as a way to defer cost. Two, if you're working on technology and you want to refine it, have like iterations to work on it, this gives you a 12-month window in which you have the opportunity to work on that. And it also helps you with public disclosures too. You filed something, so it gives you that freedom too. And another treaty that you can take advantage of is the Patent Cooperation Treaty, commonly referred to as a PCT. And basically, this allows the filing of a single international patent application for over 150 PCT contracting states. And what this basically does is it buys you 30 months for you to actually file in the countries that you want to file in. As shown in the timeline, you can file your local application. 12 months later, you can file your PCT application, and only at like month 30 do you generally need to like elect the countries you want to. And as you can appreciate, in like those 30 months, you can see how your business goes, and depending on that, decide where you want to file ultimately. And another thing that people commonly do is their first filing is a provisional application. So month 0 is that, and then at 12 months, they'll file a PCT. And then by month 30, you have to enter national phase, where you want to enter national phase. So in closing, this is a bit of a comparison between patents and trade secrets, just to side by side see what each of them do. And patents are government granted, time limited, exclusive right to exclude others from making, using, and selling the invention. In contrast, trade secrets protect confidential information that derives independent economic value from not being generally known or readily ascertainable. The duration of them are different. For patents, it's typically 20 years from the filing date if granted. Trade secrets, it can potentially run forever. You have to fully disclose your your subject matter in a patent application. For trade secrets, you cannot disclose the subject matter you want to keep as a trade secret. Patents require a formal registration process. Trade secrets are all about internal processes and procedures for maintaining secrecy in trade secrets. And patents Common examples are pharmaceuticals, technological innovations, and mechanical devices, whereas trade secrets commonly focus on proprietary algorithms, processes, and formulas. In some cases, an invention can be potentially protected, quite frankly, by both a patent and trade secret effectively. And in those cases, it really comes down to like business considerations of what you want to do. How risk tolerant are you? Are you okay with the potential that your trade secret will be disclosed? Would you prefer to have this 20-year monopoly? Or would you prefer to have a potentially indefinite thing? Being mindful that also different industries have different standards. The food and beverage industry is very trade secret heavy, whereas things like the pharmaceutical industry and the technology industry are very patent driven. So there's just business considerations in that too. Any questions relating to patents?
I'd like to make a comment before we move on. And this comes up all the time, and it's important to understand it. So we mentioned at the beginning of the presentation that patent litigation can cost millions of dollars, and it does. Now, often what startup companies will say is like, well, we can't, we're not going to get a patent because we couldn't afford patent litigation. Right? Makes a lot of sense, right? You're not going to be the one who conducts the patent litigation. What you're doing is you're buying that right for the person who buys your company. Because whatever, 9 times out of 10, the company's not going to turn into a Mighty Oak here in Vancouver. Someone will come and it'll either be a big company that will buy the technology as part of their offering, or, you know, maybe you go public and it becomes a bigger company. And so the failure to get that, first of all, you're not the one who's going to pay for the litigation. And the failure to have even kind of got a placeholder to preserve that as an option, particularly for a technology that can't be trade secret. If it's a mousetrap, if it's something people can see, it can't be a trade secret, right? You've kind of diminished your commercial prospects, and often unwittingly. Sorry.
Go ahead.
Sorry, just to like branch off of that, it's also really important to put a quality bookmark in, and we've seen this happen time and time again where people are starting out, they want a really quick patent application, and it's 5 or 10 years down the line, and they're more successful, and they want to go down patent infringement, but their patent doesn't support it. And this is something that you can't go back in time and fix easily, and it's, you have one shot, and you have one shot to do it really well too. Yes.
Maybe something that other people here might benefit from is the difference in whether you need to police infringement on a trademark versus a patent. Something I learned recently. I think a lot of people would benefit from this. You don't lose a patent if you don't, like you said, if you can't afford to go and pursue somebody, you still have your patent. Trademarks are different.
You can wait. In fact, you can sit back and watch them make a great success out of your technology and just kind of go like, shall we do it? No, not yet. And then you could shop it around. And it may be that you find if it's a real clear case of infringement, you've probably heard it that some lawyers will take those cases on contingency.
Yeah. What I was getting at was losing the registration.
To that point too, you can wait to a certain extent. There is a limitation period of, I believe it's 5 years from like the start of infringement. After that, you can't go after an infringement claim.
What I'm saying is that like if someone's infringing on your trademark, you don't do something, then eventually you can lose the registration. I think a lot of people.
You lose the registration, you lose brand value because of the harm that's occurring in the marketplace. Because the benefit of a trademark, it derives its value from its distinctiveness. If you lose that distinctiveness, it diminishes in value. And you're right, people can challenge it because they can say it's no longer distinctive because these other guys are using it. And then also there's this concept of estoppel, where once you become aware of something, you need to take action, or you may be prevented from doing so.
But to be clear, you are responsible for policing both your trademark assets and patent assets. Nobody else will do that for you.
Yeah, the point I wanted to make for everybody here, because they're founders, is that if you don't, let's say you're cash strapped and you've got a trademark, and you've got a patent. If you can't afford to go and sue somebody because they're infringing on your patent, you still have that patent, and notwithstanding statute of limitations and all that, you're not gonna lose it. With the trademark, if someone's infringing on it and you know about it, even if you don't know about it, you eventually will lose the registration. I think that's important for founders to know, is you lose your everything because of that. So it's like, it's kind of a burden having registration for a trademark. It's the shield and sword, but you also have to maintain it forever.
Say after 20 years, when the patent expired, and somebody modified that patent, can see that that same person claim ownership or?
So you definitely can get patents to, they're called improvements. They'll have a base of what's already been patented previously, and you've done something that's better, or you've modified it in any way. And as long as that new component meets the requirements of novelty, non-obviousness, and utility, you can very much go after patent protection. And it doesn't have to be like the original owner. Like, you could do that too if you have like a patent that you know has expired. And the whole purpose of the patent system really is to incentivize innovation. This is why they ask you to publicly disclose it. The government wants you to disclose this so that other people in the future can use it to like invent other things too.
Yeah, I know, what I'm saying is, the new addition, is it the one that you can only patent, or you can patent the entire thing all together, like the initial one and your new innovation? Like, you started, there's something already expired, but you now rebrand it or add more stuff into it. Can you claim the entire thing? Because, or you only claim the one that you added to the patent?
You can do both, assuming that like new component that wasn't previously disclaimed, as long as that supports like patentability, you're fine. It's just that the other elements won't, and therefore your patentability requirements will only be found in that new element. But you can go for both.
But only you can't, so the new element will be protected, but the original claims, they'll be in the public domain and anyone can use them.
Or anyone can still use the other one, okay.
Yes, just an import.
Yeah.
Question is not so much about patent, but from the kind of venture due diligence perspective, is there kind of like a minimal viable list of things that you're looking at? So let's say chain of ownership is kept within the contract, trademarks are registered in like core areas. Copyright assets have some level of tracking if there is content or value creation of some sort. There's something like a, for startup, like a minimal checklist.
I mean, ownership is, if someone hasn't registered a trademark, you could still register the trade, you could still make an application. So some things are kind of remediable. But the deal killers are chain of title. And another deal killer is if people have used bad open source in their code. We didn't get into that, but you know that there's a subset of open source software that's referred to as copyleft. And it has provisions that require you to, if you use it, to publish your source code and let people use it for free. It's like, hey, everything's free. That just kills the deal because, yeah. Or we had one instance where the company then went back, reprogrammed all of the open source. It took them a year, and then they went forward at that point.
What is it called again?
Copyleft.
Copy left.
Thank you.
Is that provisional patent you were talking about, extendable, renewable, et cetera?
No, so it's just like, it's basically a one-time bookmark for you to be able to file a regular patent application.
Or whatever you're.
You could refile it. But the problem is if you refile it, I mean, you lose that 1 year priority if someone else has come up with the invention in that meantime.
Thank you.
If they file.
Yeah.
Yeah.
Refiling.
In your provisional, it's not public, so one trick an American attorney taught me is you file all the source code in your provisional. And then when you're ready to draft like the real application, then everything in the spec is rooted in the provisional application. So you're not giving the world source code, but you can kind of like backdate your application by another year. You haven't got everything figured out yet.
One thing that I should mention that comes up in Canadian due diligence in particular is where you have government assistance or when you develop your technology on campus. Like, for example, UBC, they'll give you some free space to use sometimes, and SFU does that too. SFU isn't as aggressive with IP, but there's a shared use agreement you sign, and it's silent as to IP. If you look at the IP policy, it says that if you use UBC personnel, resources, or funding administered by UBC, then they have a claim to your IP, right? And so what happens is people are like, oh, that's silly. But no, I mean, I've spoken to I'm on the Strategic Innovation Council at UBC, and I've talked to the head of the ILO there, JP, and he's like, yeah, we keep that out of there on purpose.
University of Alberta is even more aggressive.
Yeah.
And to your question for provisional patents, like maybe you can refile, although there's risks associated with that, as mentioned. You also have to keep in mind if you're filing the provisional patent to now be able to publicly disclose and work on your research, that you're going to start that inventor originated disclosure clock, and you're going to have 12 months to file from that. Otherwise, you're outside of the period.
Could you say that again? There's a grace period for the inventor on the provisional?
Yeah, so as discussed, there's this 12-month grace period. The requirements of patentability are novelty, non-obviousness, and utility. And if an inventor discloses their subject matter, that subject matter will no longer be novel. But there's certain jurisdictions, Canada and the US, which will do grant you a 12-month grace period from such public disclosures. But there's many other countries that don't do that, which is why the general recommendation is to at least file a US provisional patent application before making any public disclosure.
Is there a test for what makes something non-obvious?
Yes, but it's abstract in that it's not the same for every situation. And you're getting into the territory of defining a person skilled in the art. So if it's a computer implemented technology, that's like heavy on like computer networking, maybe it's like a networking developer or something like that. And then you ask whether this person's skilled in the art, given everything that's been published, would they be able to come up with your invention with no inventive step? And if they can, it's considered to be obvious and not patentable. But if they need to use inventive step based on what they already know and what's been published, then it's considered non-obvious.
From an online audience, apart from employee disclosure, what are common ways trade secrets can be breached, and how can we protect ourselves as a breach?
Right, so another thing is hacking too, like so keeping up with the latest computer and cybersecurity measures, that's super helpful. Constantly updating your security measures, always helpful too. That's a common way too.
Inadvertent disclosure, people disclose by mistake, oops. And it's out there.
But I think the statistic is like over 80% of trade secret loss comes from trusted insiders.
People you fire who get mad.
Now, what are some common mistakes startups make when they think they're protecting IP?
Just not papering ownership. That's really the key thing. You just got to be able to say, here, you got to be able to come up with a list of all the people who worked on it. And then you need to be able to show, okay, well, who were they working for and what did they sign?
Or publicly disclosing before filing a patent application.
Let's say that I have a innovation and I file a professional patent. So I have 12 months to, I guess, submit additional information because I have 12 months. How long does the whole process take after I submit the whole, I guess, entirety of the application?
Like a regular application?
Yeah.
I think it depends office to office, and typically your first report, it's also in Canada, you have to request examination before you get an examiner's report. So assuming you request examination, it'll probably be like about 12 months to 18 months before you get an office action back.
Oh, okay.
Last call for questions.
One last online question. What is the best way to approach IP ownership and licensing with new client engagements, co-development with OEMs or white label to avoid ambiguity later?
Zero in on the IP provisions. Co-development is an opportunity and a risk. And so you need very clear ways. First of all, you got to take a step back and you think strategically, right? Do we want to do this? And then, so if you're looking at partnering with a big company, there could be real benefits to that. And often the incentive is we want them to get to know our technology so that they're excited enough to invest and perhaps acquire the technology, right? It becomes an exit strategy, collaboration. But one of the things that we always do in our emerging technology group is we're always mindful of keeping the exits clear. It's not just about, getting out in case of a fire. It's so easy to sign an agreement. Along comes this big company. Oh, this is so cool. We're so excited. It's Apple. And then you sign an agreement which you want to unwittingly lock up your company for 5 years. And it's like, and then if they're not interested at the end of the day, and but you can't collaborate with other people, and that's just a trap, right? So you got to be strategic and pay very close attention to those IP provisions.
Oh, boy, I want one more.
In terms of developing, I guess, with like universities and personnel at universities, if there's a situation where they're also employed by you and you say that personnel and resources from the university, they might try to claim that. How does that work? Is there, maybe that's too complicated of a question.
No, it's very important. So the first thing that happens is if you're commercializing technology that was spun off of a university, you're going to have one of their standard forms of licenses. You're going to have conflict. Like, I think that there's conflict language that managing conflict, it's like an entire article of the UBC standard license, right? And so you're going to, but you have to be completely upfront with the university about it. And if you're going to have someone, because you are allowed to do extracurricular things, and you're going to have someone on campus doing something extracurricular, do it out of their hours, off campus, not using any equipment, not like, you really have to think it through.
I did, sorry, I said last one, but I did say something about NDAs pop up, which I'm surprised hasn't been asked yet, so maybe we'll ask that as the last one.
For sure.
Okay.
How important is it for pre-seed startups of NDAs with investors?
Well, it's important, but the problem is that some investors and funds won't sign them. And so what you do is you need to have a sense of, so what that means is that you can't disclose anything that's potentially patentable that you haven't filed to protect, that you haven't at least filed a provisional on. But, think about it. You've familiarize yourself with the company's confidential information and think about concentric circles. There's the core stuff you're not going to disclose to anybody. And then there's some other stuff. This is what we plan to do, and this is generally our approach. And so you've got to have these categories of stuff that you're prepared to disclose. And there will be times for potential investors where they won't sign an NDA. And if they're really big, maybe you're going to live with that. Like we've had clients that would live with it. And quite frankly, those investors, if they're reputable, if they're successful, they're not going to take your stuff, right? Because that's just not what they do. Not just because it's reputationally bad for them, but they don't need to do that. They're making money investing in companies. But as a starting point, always try to get the NDA.
All right, we good? Okay, so first, thank you, Roger and Nina, for presentation and all the time.